Can any one of you unmute yourself and tell me if I'm audible or not? All right. So, yeah. So let's start. We were about to study about the general defenses for torts. Yeah. So the general defenses when we are talking about the tort law in India as well as mostly in the abroad countries as well. So the general defenses include volenti non fit injuria. That's a legal maxim for implying the consent. All right. Then there's the plaintiff, the wrongdoer, which means if the sufferer or the plaintiff who has lost a complaint, including a violation of his legal rights or something, and if the plaintiff was at the fault, so he cannot take the defenses under the tort law. Then the next is inevitable accident. Inevitable accident is something, say there's an accident or there's a mishappening which would not have been avoided, which could not have been avoided by regular care or even by reasonable foresight. All right. Then there's act of god, which includes any natural calamity or mishappening where humans don't have any sort of control over those incidents. All right. The next is private defense. All right, private defenses, we'll study them in detail. Then this general defense include mistake, necessity, and statutory authority. Statutory authority include the powers vested to the state or the workers for or the employees for state who can to some extent breach the rights under the tort law. All right. So these are some of the general defenses which are covered under tort law, and we will study them in detail now. So the first one, which is voluntary non-fit injuria or the defense of consent. Okay, this legal maxim implies the defense of consent. Okay, so when a person consents to the infliction of some harm upon himself, he has no remedy for that in tort. All right. Understand it in this way that a person voluntarily waived or abandoned his or her right. Okay. So while abandoning the right or while waiving the right voluntarily, the person cannot claim at a later point of time ki by that particular right has been breached, which he has already waived. All right, you cannot claim anything which you have already waived voluntarily. Okay, so in the tort law, in the ambit of tort law, when a person consents to say any sort of harm which can be which is foreseeable or apparent, all right, upon himself, or it is a general course of functioning that this particular harm can be there in the general course of functioning for any particular event, he has no remedy for that in tort law. Okay, the catch here is for that in tort law he might get some remedy in criminal law or some other legal provision, but tort law doesn't recognize any such remedy when the consent is from the plaintiff himself. Okay, and imagine when you invite somebody to your house. Okay, when you invite somebody to your house, you cannot sue him for trespass, nor you can sue, all right, you cannot sue him for the trespass. There's a guest in your house, you cannot say acha, till dinner you were okay, I invited you, but then you had some sort of argument and suddenly you claim that you are trespassing on my property. No, you cannot do that because you yourself gave the consent for him to enter. Okay, the next instance is, say you cannot sue the surgeon. All right, to a surgical operation because you have expressly consented to these activities. Okay, you have expressly consented to these activities. It's not the case that you go on for a stomach surgery and then after the surgery has been done, you get up and claim, oh, all right, you dissected my stomach, but this was not something to which I have consented. No, this is not the case. You have expressly consented to these activities of surgery. Similarly, no action for defamation can be brought by a person who agrees to the publication of matter defamatory to himself. Okay? The next one. The next one is many at the consent. We will be continuing with the consent or the previous maxim, which was volenti non fit injuria. So many a times the consent may be implied or inferred from the conduct of the parties. The parties include the plaintiff as well. Okay? The parties, as in the case of Hall versus Brooklands Auto Racing Club. This is a case law, a landmark judgment which concluded with the statement that the consent does not need to be expressly stated. All right, it can be implied or inferred from the conduct of the parties. Now, the facts were the plaintiff was a spectator at a motor car racing being held at Brooklands on a track owned by the defendant company. Okay, during the race there was a collision of two cars, one of which was thrown among the spectators. Okay, imagine this as you might have seen that Maut Ka Kua type thing in circus, right? Imagine one of the cars colliding with the another and one of them getting thrown amidst the spectators. Okay? Now, this accident happened and thereby the plaintiff was injured. Okay? Now, it was held that the plaintiff impliedly took the risk of such injury. The danger is inherent in the sport, which any spectator could foresee. Therefore, the defendant was not liable. So, what the bench held in this particular case law was, because that was a motor car racing or say activity, it is reasonably foreseeable that there might be a collision of two cars. Okay, there might be a collision of two cars, and the plaintiff, by the conduct of entering into the arena, impliedly agreed. Okay, impliedly agreed to this particular danger or mishappening by his conduct of entering into the arena. Okay, so the consent in these voluntary non-fit injuria cases shall not necessarily be expressly stated, but they can be inferred from the conduct as well. Okay, the next one. The next one is for the defense to be valid. Okay, for the defense to be valid, the 2 points mentioned below shall be proved. What are the 2 points? All right, it's not the case that any time the defendant can be provided with the particular defense. Acha, there was a consent from the side of say the plaintiff, and the defendant could be could be freed without any liability. No, there has to be some test, right? Because there has to be some objectivity whether what all consents are substantial and what all consents are just like minute points in the actual incident, which was not a contributing factor to the entire incident. So for the defense to be valid, the first point is the plaintiff should be aware of the risk. Okay, and the second one is knowing the same, plaintiff agreed to suffer. Okay, and there's one more important point, which is if there was any element of fraud, misrepresentation, or mistake, the defense of consent won't be valid. Okay, while we are talking about consent, and because you have already studied contract law, you know that the consent can be influenced or can be obtained by certain means such as fraud, misrepresentation, or mistake. Okay, so in such cases, the defense of consent won't be a valid one. Now, there's an important case law. There's an important case law which is Smith versus Baker, wherein the plaintiff was a workman employed by the defendants on working on a drill for the purpose of cutting a rock. Okay? with the help of a crane, stones were being conveyed from one side to the other, and each time when the stones were conveyed, the crane passed over the plaintiff's head. Okay? The crane, while conveying the stone, passed over the plaintiff's head. यहाँ तक clear? While he was busy with his work and in the due process of conveying the stone, a stone fell from the crane and injured the plaintiff. Okay? Now, it was held by the House of Lords in this particular case, Smith versus Baker, that there was mere knowledge of risk without the assumption of it. Okay? The maxim volenti non fit injuria did not apply and defendants were liable. Now, why is this case different from the previous cases or from the previous instances where we have discussed that there's only while the consent is there, the defendant won't be liable. So in this particular case, although he was aware that cranes are carrying stone over his head or over the workers, but he was not aware that there can be an instance जहाँ पे the stone can fall on him. ठीक है? Unlike the previous case where it was very clear that two cars can collide in the due process of a car race. ठीक है? So while we use this particular condition, all right, so the plaintiff was aware of the risk, all right, he had mere knowledge ki acha there's some crane carrying some stones over them, okay, but knowing the same, the plaintiff agreed to suffer? No, because he did not assume that the stones can fall on him, or the stones can fall on him, or there's some or if he would have been informed about the same, it is not clear whether he would have carried out the function. Okay? Stop me anytime when you face any sort of difficulty. I'll explain it to you. The next one is plaintiff, the wrongdoer. Okay? Plaintiff, the wrongdoer. Now, what does this defense imply? As I have earlier explained this to you, that plaintiff, the wrongdoer, in certain cases, it is the plaintiff. It is the plaintiff who is at fault. So the plaintiff cannot claim violation of his tortious rights. All right. Now, the next one is, matlab what the law says. The law excuses the defendant when the act done by plaintiff was illegal or wrong. Okay? When the act done by plaintiff was illegal or wrong. Okay. So an unlawful act of the plaintiff itself might lead to a valid defense in torts. This applies not only to tort law but to contract, restitution, property and trust. Okay? In any of the legal provisions or legal in any of the acts, it is a recognized fact that if the plaintiff himself is the wrongdoer, there shall be some relaxation to the defendant, if not completely exonerating him from the charges. Okay? Now, in Bird versus Holbrook, this is again a case law. You need not remember the exact name of the case laws, but remember them as the instances, okay, in order to differentiate what conditions are essential or what conditions can lead to defying the defense. Okay? You need not remember the case law, but remember what was held in the particular cases. So the plaintiff in this particular case, trespasser over the defendant's land, was entitled to claim a compensation for injury caused by a spring gun used by the defendant without notice in his garden. Okay? Under this defense, it has to be seen as to what is the connection between the plaintiff's wrongful act and the harm suffered by him. If his own act is the determining cause of the harm suffered by him, he has no cause of action. Again, the same thing. Volenti non-fit injuria also had an exception. And in the similar way, this plaintiff, the wrongdoer, also has an exception that even if in some instances the plaintiff has committed some sort of wrong or illegal activity, it has to be clearly determined whether his illegal activity was the contributing factor to the entire harm suffered by him. Okay? All right, the next one. Mm, yeah, the next is about inevitable accident. So in an inevitable accident, this also can be used as a defense by the defendants involved in the tortious liability cases, where it says an accident means an unexpected injury. And if the same could not have been foreseen and avoided in spite of reasonable care on the part of the defender, it is the inevitable accident. Okay? Before we move forward, an instant just came up in my mind. Yes. Uh, yes. While we were talking about the consent thing, there's another very famous example. All right, there's another very famous example, such as this case where the motor cars collided. There's another very famous example that the plaintiff entered into a stadium for a to watch a cricket match. Okay? And while in the due course of this particular match, uh, these one of the batsmen hit the ball and the ball landed up on the plaintiff and injuring him. Okay? The ball caused certain injury upon the plaintiff, and the plaintiff claimed for compensation, but it was held that the act of entering into the stadium implies the consent from the conduct of the plaintiff. Okay? Therefore, the defendant was not held, not liable in this particular case. Okay? So you need to be well clear with these instances. Now, let's get back to the inevitable accident part. This inevitable accident. An accident means, all right, we have read this part, and what involves an inevitable accident, any accident which was not foreseeable and even after due care could not have been avoided. Okay? In spite of reasonable care on the part of the defender. Okay? मतलब an accident, because the name suggests that for itself ki inevitable accident, that even after reasonable care it was not possible for any human being to avoid that accident. Now, it is therefore a good defense if the defendant can show that he neither intended to injure the plaintiff nor could he avoid the injury by taking reasonable care. Okay? Nor could he avoid the injury by taking reasonable care. Now, in another case law, which was Stanley versus Powell, the plaintiff was employed to carry a cartridge for a shooting party when they had gone for a peasant shooting. Okay? A member of the party fired at a distance, but the bullet, after hitting a tree, rebounded to the plaintiff. All right, imagine this. Say this is the tree somewhere. This is the tree, and this is the plaintiff, and this is the defendant. Okay, so the defendant fired, but instead of going directly to the bird, it went to the tree. All right, now if a bullet hits a tree, it is not reasonably foreseeable it will rebound. Okay, but the bullet did, and it went to the plaintiff. Okay, now the plaintiff filed for compensation, but it was held that in no possible circumstance this was reasonably foreseeable that a bullet would rebound after hitting a tree and would hit directly to the plaintiff. The chain of causation is getting very remote. First, the bullet would hit the tree, all right, then the bullet would rebound, then again the rebounded bullet would hit nowhere else but the plaintiff himself. Okay, so this was highly unlikely, and therefore the defendant was not was held as not liable. Now, these instances, or this particular defense is available only when the event is unforeseeable, only when the event is unforeseeable, and second, consequences avoidable in spite of reasonable precautions. Okay, and it has to be shown that there has been reasonable care from the side of the defendant to avoid such accidents. Okay, now if we need to see what are the reasonable precautions in any circumstance, there is no such test. Okay, but we can infer them from the material circumstances in the case law. Now, see, in this particular case, Stanley versus Powell, what is the fact which shows that reasonable precautions were taken? This line that party fired at a distance. Okay, now proper distance was followed in this particular instance. Okay, proper distance was take proper reasonable precautions were taken in this particular instance by firing at a distance, but the chain of causation was too remote, and in spite of that reasonable care, the bullet went on hitting the plaintiff. Okay, therefore the defendant was not held to be liable. The next point, which is the act of God. Okay, now what is act of God? Can any one of you tell me what are under act of God? Like, what can act of God encapsulate? What all incidents are can be classified as act of God? Either you can unmute yourself or like type it in the chat box. What is natural and sudden, like floods, and what else? Like what some other incidents as well? Earthquake, yes. Glacier burst, yes. Perfect. So when we talk about act of God, an act of God serves as a good defense under the law of torts. Okay? Under the law of torts. It is also recognized as a valid defense in this rule of strict liability in the case of Rallens versus Fletcher. Rallens versus Fletcher is a landmark judgment which describes your aspect of strict liability which you have studied in the previous class. Okay? Now, the defense of act of God and inevitable incident might look the same. Okay? They might look the same. Okay? Even inevitable incident cannot be avoided, and same is with act of God as well. Okay? It cannot be avoided, but there has to be some difference, right? Then only these two defenses can be distinguished. And what is that distinguishable element? That is, act of God is a kind of inevitable accident in which the natural forces play their role and causes damage, which include heavy rainfall, storms, tides, glacier bursts, anything. Okay. Now, this line that act of God is a kind of inevitable incident. Now, if I may draw your attention to the set theory, the concept of set theory, which you are aware, all right, say act of God is a kind of inevitable accident, which means inevitable accident is the larger circle or the larger ambit, and act of God is one specific kind of inevitable incident. Okay, this is act of God, this is inevitable accident. Okay, inevitable accident involves a lot of more accidents where which cannot be avoided. Perfect. And act of God involves specifically those accidents where the natural forces play their role to cause the damage. Okay? Where natural forces play their role to cause the damage, which means you can write all act of God incidents are inevitable accident, but the vice versa is not true. Okay, because there are certain part of inevitable accident which are not a part of act of God. Okay, this is a bit on the mathematical or logical reasoning side, but this is something which has been featured in the mocks and the actual papers of several competitive exams as well. This all act of God incidents are inevitable accidents, or all inevitable accidents are act of God. Okay? So whenever you encounter such question, remember all act of God incidents are a part of inevitable accidents, but vice versa is not true. Okay? All right. Then essentials required for this defense are, now what are, there has to be some essential points, right? As we have discussed in the previous defenses, key some points need to be fulfilled in order to take this defense particularly. Now, what are the essentials? The first is natural forces working should be there. All right. Now, you cannot take the defense of act of God in, say, any other inevitable cases of, say, car accident or a person slipping on the road or something. Okay? The natural forces should be working there. All right. And then there must be an extraordinary occurrence and not the one which could be anticipated and guarded against reasonably. Okay? This is very important point, this point, that it should be an extraordinary occurrence. Now imagine an instance, okay, there on a particular morning it started raining, and a person claimed that because it is raining he cannot attend the office or he cannot be present in the office. And then he claims that that rain is an act of God specifically, therefore he is not responsible for the delay or being absent. But on that particular day there have been two clauses playing, that the person is living in an area where rainfall is common. Okay? And on that particular day the rainfall was not that heavy, it was some light showers. So can he take the defense of act of God? And if yes, then why? If not, then why? Bolo. बताओ. वो ले सकता है डिफेंस एक्ट ऑफ गॉड का. सोचो 2 मिनट फिर बताओ. नहीं आया समझ में. Write in the chat box if you are not comfortable with speaking. Can you take the defense when the rainfall was not that heavy and it was kind of predictable because the area in which he lives is prone to such light showers? देखो he cannot take the defense. अब क्यों? While natural forces are obviously playing there, ठीक है, working there, as rainfall is uh, is an act of God, ठीक है, rainfall is an act of God, agreed. But in order to take act of God as a defense, there must be two conditions satisfied. First is this and second is this. And in the second condition, there's a phrase that extraordinary occurrence. But was this an extraordinary occurrence? No, because first that was a light shower, and second that the rainfall was common in that particular area. Therefore, even if this first condition is satisfied, the second is not. Okay? Therefore, this act of God defense cannot be effectively taken in this particular instance. All right. So you need to be very careful while classifying any defense as act while providing the defendant with this defense act of God, that these two conditions should be satisfied. That all right, these are not clearly two conditions, these are three conditions. First is the natural forces should be working there. The second is it should be an extraordinary occurrence. And third is you need to be clear with these words: anticipated and guarded against reasonably. Okay? Now, the next is private defense. What is private defense? If we are calculating everything under the ambit of defense, it is the law has given permission to protect one's life and property. Okay? Because right to property is something which we are vested with, but it has allowed, therefore it has allowed the use of reasonable force to protect himself and his property. Now that you have the right to protect your own self and your property, so you can use reasonable force to protect these two components. If it's say you are under some threat or your property is under threat of being captured, all right, so in order to effectuate this right of property, you are vested with this right that you can use reasonable force. But again, these 2 points should be satisfied, which is the first one is the use of force is justified only for the purpose of self defense. Okay? Now, self defense, this is the catchphrase. Self defense. ठीक है? You cannot say कि अच्छा I thought मेरे साथ ये हो सकता है इसलिए I used this particular force, or because this can be something that can be under attack in future, so I attack this person today. You cannot attack in the first place. You can only use force for self defense. Okay? Then the second condition is there should be an imminent threat to a person's life or property. All right, the threat component has to be present over there. All right, without threat component you can't say ki, acha, I have this private defense, so I'll hit anyone who steps into my in my property. No, there was no threat. If say a person mistakenly stepped into your property, there was no threat to your property. You could have simply just notified that person, all right, this is my property, you cannot get into this particular land, or you cannot step on this particular land. But if you chose to apply some force or uh, attack the person, then you cannot use the defense of private defense under tort law. Okay? For example, A would not be justified in using force against B just because he believes that someday he will be attacked by B. ठीक है? All right, इसमें कुछ satisfy हुआ नहीं. All right, the use of force, self defense नहीं था, attack ही नहीं हुआ, self defense कहाँ से आएगा? Then there was no imminent threat. ठीक है? There was no clear threat. यहाँ पे he believes. All right, in legal reasoning or legal comprehension, you need to be very careful with the words which are used. He believes. All right, he was not informed by B himself, he was not informed by the other person. Okay, he believes that someday he will be attacked by B, therefore there was no imminent threat. All right, now for another instance, if A tried to commit a robbery in the house of B and B just draw his sword and chopped his head, then this act of A would not be justified and the defense of private defense cannot be pleaded. Okay, now there has to be another factor, because this one there was imminent threat, yes. It was for self defense, yes. But again, why did this defense cannot is not workable in such scenario? Because the word reasonable force. All right, because of the word reasonable force, this was not reasonable ki acha there's a robber, you to take your sword and just chop off his head. No, you cannot do that. You can threaten that robber, you can obviously cause some minor injuries, but you can not directly chop off his head. No, that is unreasonable. Okay, and there is a special emphasis on reasonable force. Okay, so again here there are three conditions: the use of force for self defense, there should be imminent threat, and with this reasonable force. Okay, sure. Next one. The next is about mistake. Now, the mistake in tort law is of two types, which is mistake of law or mistake of fact. Okay? In both the conditions, no defense is available to the defendant, and mistake is something which cannot be taken, as a defense to the tortious liability. Okay? Say there's a famous case law that A brought some contraband items from a foreign country while A was not a resident of India. In the due course of traveling, A brought some contraband items to India via flight, and he was detained at the airport. All right. Now, while he was detained at the airport, because the plaintiff A claimed that he was not aware that there's a law which prohibits the carrying of this particular element. So this cannot be taken as a valid defense under tort law, because this was a clear mistake of law. He was not aware, or he mistakenly was not aware of law, but this cannot be taken as a defense in tort law. All right. Similarly, in this case, which is Consolidated Company versus Curtis, an auctioneer auctioned some goods of his customer, believing that the goods belong to him. Okay? But then the true owner filed a suit against the auctioneer for the tort of conversion. Okay? The court held auctioneer liable and mentioned that mistake of fact is not a defense that can be pleaded here. Okay? There was a mistake of fact that auctioneer believed that those goods are his, but because mistake of fact is not a defense under tort law, therefore he was not provided the with the leverage of pleading such a defense. Okay, the next one. The next one is, if an act is done to prevent greater harm. Okay, if an act is done to prevent greater harm, even though the act was done intentionally, right? Necessity, even though the act was done intentionally, it is not actionable and serves as a good defense. All right. Now, the following points should be considered. What are the following points? In necessity, the infliction of harm is upon an innocent, whereas in case of private defense, the plaintiff is himself a wrongdoer. Okay? Now, necessity, there's an act, say there's something, there's an act against which some another act has to be done in order to prevent a greater harm. Okay? All right. So even the act, even if the act was done intentionally in order to prevent the greater harm, obviously, then this act would not be actionable. All right. You cannot claim for tortious liability against this particular act. Okay. Now, the difference here is that in the cases involving necessity, the harm is upon an innocent. Okay. Whereas in case of private defense, the plaintiff is himself a wrongdoer. Okay? In necessity, the harm is done intentionally, whereas in case of an inevitable in accident, the harm is caused in spite of making all efforts to avoid it. Okay? So when we are talking about necessity, the intention factor comes into play, unlike the inevitable accident where there was no intention to cause that particular harm. All right. For example, performing an operation of an unconscious patient just to save his life is justified. Now, although the person did not consent for operation, but because it was necessary to save his life, the doctor can operate him without the due permission. All right. And this won't be considered as a violation of the right. Okay. Now, in the case of Carter versus Thomas, the defendant who entered the plaintiff's land premises in good faith, okay, in good faith to extinguish the fire at which the fire extinguishing workmen were already working, was held of the guilty of offense of trespass. Now, this is something you need to be aware of. Why this is important? Because see, all the conditions were justified. Good faith was there in order to prevent greater harm, fire, all right. But again, there was an additional clause that fire extinguishing workmen were already working there. Okay? So it was not the need of the hour. It was not necessary that this particular person, plaintiff, should enter into the premise. Enter into the that particular defendant should enter into the premises of that particular person in order to help. No, because there were already so many competent person working to extinguish the fire, that was not under the necessity. Okay, so you need to be careful with the substantial facts involved in the case. All right, you need to see that what level of necessity was present over there. Okay, the next one, which is statutory authority. Now, if an act is authorized by any act or statute, okay, then it is not actionable, even if it would constitute a tort otherwise. All right, even if it would constitute a tort otherwise, it is a complete defense, and the injured party has no remedy except for claiming compensation, as may have been provided by the statute. Now, what you need to know is in this particular thing that there are certain statutes that empower the public professionals or the government servants in the public servants to say infringe the tortious rights to some extent of the people, like if there's a warrant with any particular police officer and that particular police officer enters the premises of a criminal, or a person which might not be the criminal, that person cannot claim compensation under the tortious liability, because the provision for warrant itself provides for the particular infringement. Okay, and the relevant section provides for this particular thing. Now, immunity under statutory authority is not given only for the harm which is obvious, but also for the harm which is incidental. Okay, now there are certain harms which are say indirect, and there are certain harms which are say direct, like obvious. So in certain cases it is but both the type of harms are covered under the statute. All right. Now, the next one is in Vaughan versus Taftwilder Rail Company, sparks from an engine of the respondent's railway company were authorized to run the railway, set fire to the appellant's woods on the adjoining land. Okay? Now, it was held that since they did not do anything which was prohibited by statute and took due care and precaution, they were not liable. Now, see, because this particular case involved the railway company, which was authorized by the government to run railway, and the fire was although caused, but there was nothing faulty done by the railway company themselves, which was prohibited by the statute itself, and due care and precaution was adopted. Okay, therefore the railway company was not held to be liable. Okay, the next one, and in this particular case, this was not an obvious harm. Okay, because this was not a direct harm, this was an incidental harm. Okay, the next one, statutory authority. Again, there's a case law, another case law, where in Smith versus London and South Western Railway Company, the servants of a railway company negligently left the trimmings of hedges near the railway lines. Okay? The sparks from the engine set fire to those hedges, and due to high winds, it got spread to the plaintiff's cottage, which was not very far from the line. Now, the court held that the railway authority was negligent in leaving the grass hedges near the railway line, and the plaintiff was entitled to claim the compensation for the loss suffered. All right. So, what different are how different are the substantial facts in this particular case in with respect to the previous one, where both of them involves a railway company which was authorized by government, and an incident which say was incidental. Now, the only different fact over in these two cases is that the railway company negligently left the trimmings of hedges near the railway line. Okay? They negligently left the trimmings of hedges near the railway line. So negligence was there. All right. And while we are discussing about statutory authority, it is important that due precaution and care has to be observed, and nothing has to be done which is contrary to the provision. Okay? So negligent act would disentitle the railway company from claiming the defense of statutory authority. Okay, so you need to be aware of the material circumstances. Okay, first it should be permitted by a statute, and second, no negligence, and no incorrect act. Okay, these are the two conditions which has to be satisfied, satisfied. Now, the last point is absolute and conditional. The authority given by a statute can be of two types. First, it is absolute, and second, it is conditional. Okay? In the case of absolute authority, there is no liability if the nuisance or some other harms, if the nuisance or some other harm necessarily results, but when the authority is conditional, it means that the same is possible without nuisance or any other harm. Okay? So in absolute authority, no liability, and in conditional, it is possible. Okay? Conditional में absolute absolute authority में, even if the authority is say what say negligent, but the act covers that negligent part in order to prevent some greater harm. But in conditional authority, say the act specifies instances that the act should not be negligent, should not be this, should not be that. So these are the conditional authorities. In the case of Metropolitan Asylum District versus Hill, the hospital authorities were granted permission to set up a smallpox hospital, but the hospital was created in a residential area which was not safe for the residents, as the disease can spread to that area. Considering it a nuisance, an injunction was issued against the hospital. The authority in this case was conditional. Okay? Now, although the hospital authority was permitted to set up a smallpox hospital, but because it did not follow the due care, therefore the hospital authority was held to be liable in this case. And because this due care factor crept into the scene, okay? Because say if this entire due conditional would not have been there, if this was a case of absolute authority, then the hospital authorities would not have been held as liable. But because the court held that hospital authorities are liable for this nuisance as they did not observe due care, therefore the authority given to them in this particular case was absolute. Okay, was absolute, was sorry, conditional and not absolute. All right. So the difference between absolute and conditional: absolute involves all the covers all the loopholes. Okay, it eradicates all the loopholes. Okay, the act might be negligent, but it's not an issue in order to prevent the greater harm. All right. But in conditional, these due diligence, due care, reasonable care play an important part. Okay. So we are done with the theoretical part, and I have some questions prepared for you, say 5 or 6 questions on defenses of tort law, but I guess the time is up. All right, we'll discuss one or two. Okay, we'll discuss some of the questions. Now, the first is, the principle is an act of God in an operation of natural forces so unexpected that no human foresight or skill could reasonably be expected to anticipate it. Okay? And what are the facts? Facts are the Patanjali housing complex was celebrating its 10th anniversary and arranged for a concert by Shanikrama, a leading musical group. Okay? The event was organized in one of the best auditoriums, and all the tickets were sold out. On the day of the event, an earthquake destroyed many buildings, including the auditorium. People who had purchased the tickets asked for refund from the Patanjali housing complex as the show could not take place. So tell me, which of the following options would be correct? First, the Patanjali housing complex must refund the cost of tickets. Second, the management of the auditorium must refund. Third, neither Patanjali complex nor anyone else need to refund the cost of ticket as it is an act of God. Or third, the ticket holders can demand the show to be organized at a later point of time. Yes, C, because this was an act of God and the conditions were satisfied. That first, it could not be reasonably foreseeable, and even after due care, earthquake cannot be prevented. Okay? So the correct option would be C. And the other way to look for while you are solving these legal questions is that you can, if you are not sure of which is the correct answer, you can check with the option which is closest to the principle itself. Okay, the principle mentions about act of God. There's only one option which mentions about act of God, is option C. So before going with any other options, you can once check with the option, or there might be only two such options. Okay, which are closest to the principle, the wording of the principle. All right, so we'll continue with the rest of the questions in the upcoming classes. All right, and we'll end this session here. Thank you so much.